It is a medieval courtroom. The candles are nervous, the clerk is exhausted, and the defendant is a pig. Not a metaphor, an actual pig. Welcome to Filthy History. Today, animals put on trial for crimes. The prosecution has witnesses, the judge has a hat, and the defense lawyer has a client who keeps eating the evidence. To understand the case, start outside. Medieval villages were crowded with working animals, loose livestock, children, waste, and very few helpful warning signs. Before we laugh at the pig, the human harm was real. Pigs could be dangerous, especially around unattended infants. The absurd part is the paperwork deciding the pig needed a legal strategy. The surviving records are patchy because history files itself like a drunk clerk. But documented animal trials ran across Europe from the 13th to the 18th century. France preserved a lot of the paperwork, which is why this episode keeps sounding French. That is not bias. That is just who forgot to throw away the pig receipts. There were two main tracks. Secular courts handled domestic animals, pigs, bulls, horses, cows. Church courts handled pests, rats, weevils, caterpillars, and other tiny defendants with excellent attendance problems. The proceedings could look weirdly human. Witnesses were heard, charges were read. In some cases, animals were assigned legal help because justice demanded a lawyer fluent in silence. Once arrested, the animal could be kept in actual custody. Imagine being the jailer who has to feed the prisoner and also sweep around him. The owner was not always safe either. Medieval rules could treat him as negligent, complicit, fined, or forced to surrender the animal. Congratulations, your pig is now evidence. In Falaise in 1386, a sow was tried after killing and mutilating a child. The punishment mirrored the injuries, then the animal was hanged. Medieval justice loved symbolism too much. Punishment was often public. Professional executioners carried it out, crowds watched, and sometimes the animal was dressed in human clothing first, naturally. That clothing detail is the whole system in miniature. The court wanted the pig to look enough like a person that punishing it made public sense. Pigs show up constantly because they live near people and ate almost anything. One inventory found 15 cases from the 13th to 16th centuries where pigs were executed for killing children. Then Burgundy enters, wearing its important hat. In 1379, 2 herds of pigs were accused of joining a deadly pig riot. The guilty animals were condemned, but the 2 herds accused as accomplices were pardoned by the Duke of Burgundy. Even medieval pig law had an appeals process. Please picture the paperwork. Count every pig, assign blame by herd, prepare the pardon, seal it, then pretend this is less embarrassing than admitting the system is guessing. In Savigny in 1457, a sow was convicted of murder, but her 6 piglets were acquitted. They were young, and there was no evidence against them. Tiny legal victory. Near Clermont in 1494, a young pig was tried after a child's death, and witnesses were examined. The court did not skip procedure just because the defendant lacked pockets. Now leave the pig courtroom and enter pest court, where the defendant list gets smaller, faster, and much harder to subpoena. Ecclesiastical courts handled crop destroyers, rats, caterpillars, flies, moles, worms, snails, leeches. The goal was usually to make them leave, which is ambitious customer service. The champion of this genre was Bartholomew Chassenet, a French jurist who defended rats accused of destroying barley around autumn. His clients rudely did not attend. Chassenet argued the rats may not have received the summons, and even if they had, traveling to court was unsafe because of cats. That is annoyingly good lawyering. For pests, the legal remedy could slide into exorcisms, holy water, curses, and formal warnings. It is agriculture by paperwork, prayer, and increasingly desperate vibes. In one vineyard case from 1587, weevils accused of damaging vines were treated as having a natural right to eat, and a separate patch was proposed for them: bug zoning. Switzerland contributed the 1474 Basel rooster case. The bird was accused of laying an egg, which people feared could produce a cockatrice. The rooster and egg were burned. Modern biology has explanations for odd sex traits in chickens. Basel had a monster theory, a court date, and apparently no one willing to say, maybe call a farmer. Not everyone bought the logic. Roman law, Thomas Aquinas, and the French jurist Philippe de Remy all had versions of the same objection. Animals cannot understand law or form criminal intent. So why keep doing it? Historians suggest deterrence, public spectacle, religious order, and a need to make random disaster feel governed. Basically, chaos entered, paperwork took attendance. And the system was not always bloodthirsty. Piglets could be acquitted, herds could be pardoned, rats could win on travel safety. The bar was strange, but it existed. This is the weird belief engine. If the world scares you, make it answer in court, even if the answer is squealing, chewing barley, or laying the wrong egg. Today, most criminal systems do not treat animals as culpable because moral agency matters. We still manage animal danger, but we no longer appoint a barrister for breakfast. So the verdict is this: the animals were not secretly criminal masterminds. The courts were trying to turn fear, danger, and bad luck into something with a docket number. I have been your host. Thank you for watching Filthy History. If your pig is in court, say nothing, request counsel, and please stop eating Exhibit A.